town then has the obligation not to continue to pay that person for that position, and is going to have to make arrangements to see that the clerk's duties are provided for.
The court clerk's position isn't a public office position, as you stated. You said that the two positions of public office are incompatible. They're not, the one court clerk is not a public officer's position. It's an appointment.
Right, an appointed office is a public office. Section 30 of the Public Officers Law defines it as such.
Then the court clerk's position has been a public officer?
It's a public office. Anybody that is elected or appointed to employment in the public sector is in a public office. So that's what the town board has to, resolve to do, and it's, perhaps not a pleasant situation to be in, but it's not one that the town board created. This is the, this is the law as it exists currently, and it's been that way for quite a while.
Can I just add one more thing? The opinions from the Attorney General are not formal legal binding opinions. The opinions that come from the town attorney are suggestions based on informal, non-binding opinions from the Attorney General when it comes to town government.
Yeah. When you say non-binding, the Attorney General gives an opinion. He's saying what the status of the law in New York is.
An informal
they
opinion?
Are, even if they say it's an informal opinion. Okay. So that, and perhaps the most recent case on the subject, and Hill versus Hall, the court goes at great length to give the whole history of this subject of incompatible offices, and the courts, too, even in this decision, cite to what you call the informal opinions of the Attorney General. They see that as precedent for the court to rely on. And so too, as the courts do, that the town has to rely on the opinions of the Attorney General. So it, we've looked through these, and there are really no other decisions. That the line of cases, going back, as the court puts it, back to the common law, make this clear as far as what the result would be. So I think the town board has no other alternative but to accept the opinion of the Attorney General, and the then legal consequence of that is that the position of court clerk that Judge Van Wert held is now vacant.
Like today?
Technically, it was vacated
in 1997.
Right, but you're only getting this opinion now. This issue has only come up now. They would have to take effect immediately.
I can't speak for Michelle. I yield the floor to her. That's the proper
I
rule.
have John Siegel working on it right now.
So
it's still, I don't believe that the Attorney General did their due diligence with regard to this situation. It's unique. So I'll just defer till my attorney can contact the county board. If that's the position, I don't know how we will work that.
Just thinking out loud.
Yeah.
For me, it's just like, well, you know, for several reasons, I can't, and I, you know, I have no opinion. I mean, it sounds like, you know, it is what it is. You guys will kind of figure it out. But, you know, in the normal business, even if something like this would happen, you get some kind of a severance package. Not that I can say that because this isn't a business. It's been drilled into my head pretty hard over the last few months. But on the other hand, I got to think too of the town and the court. We need to keep it going. We can't just cut it off. And I guess number 3 of my logical thinking here is that, you know, if there is a process that you need to appeal or the right to appeal, I guess, if there is such a thing in this particular case, and I'd like to give you that opportunity to do that. So with all that above,
Thank you.
is that an option for the town board?
Maybe just reading from part of this court decision makes it clear. It says, it's a well-settled rule of the common law. A public officer cannot hold 2 incompatible offices at the same time. The rule is founded upon the plainest principles of public policy. It is embedded in the common law and has obtained from very early times. Common law and under constitutional and statutory prohibitions against the holding of incompatible offices, a person who accepts and qualifies for a second and incompatible office is generally held to vacate or by implication resign the first office, so that no judicial proceedings are necessary to determine the title. The successor may at once be elected or appointed. So, the court saying the town needs to take no further action by operation of law. The first position is vacated. If there's, you know, somebody wants to challenge that principle, then it would be up to the other person, not the employer, not the town. The person.
So let me get this straight, Mike. You're saying that this is a done deal as we see it right now? That she can't hold both positions?
That's what the Attorney General is telling us. That's what the court decision is.
Well, then we have no...
We don't have any alternative. If the judge wants to challenge that in court, then that seems to be what her recourse would be. And she would bring an action for declaratory judgment in Supreme Court, Schenectady County, to have a judge then look at this again to see if he somehow disagrees with the Attorney General.
Well, then it's out of our hands right now.
What opinion are you reading, Mr. Cuevas?
This is from 2002 case. It's Held versus Hall.
H-E-L-D?
H-E-L-D is the petitioner, and Hall, H-A-L-L, is the respondent.
Okay, thank you.
So I still kind of think, again, just my opinion, and I know it's probably in violation of whatever Mike just read, and, you know, again,
You have another principle that you have to be concerned about, and that is that New York State Constitution does not allow you to make gifts of public funds. So once you have a determination that you can no longer pay someone, you cannot gratuitously offer something that's not part of their compensation package. So you cannot extend additional benefits to employees just because it's done in the private sector. It doesn't work that way in the public sector.
So, I mean,
If there were union contracts in place that said somebody's entitled to, you know, certain types of payouts and things like that because of accumulated vacation time or, you know, personal time and things like that, you know, then you're authorized to pay that. If there's a town policy, written town policy that says people not covered by a collective bargaining agreement are entitled to certain kinds of payouts, you can do that. But you can't, after the fact, fashion additional compensation.
gratuitously?
Right.
So what if I don't know, say, I want to turn off the TV here for a second, but if there's a, you know, and I'm looking at it from the town perspective, at least I think I am, I hope I am, that we need to transition, let's say, if that's the, we need to, from, I guess, hopefully the board, at least my perspective, is that we need to keep the business of the town going, and to say that, boom, at this time today, Michelle no longer works here. I don't think that's, fair. I gotta be careful, but it's not fair to the town. So if Michelle just continued to work, for while we transition, is that still considered gratuitous?
Well, if a judge wants to do other work, there's probably nothing to prevent her from doing that, but you would be prevented from paying her.
That says it all.
I guess I don't really follow. I mean, we have a couple of opinions and you have some information about another case. I don't understand how that's binding to the town to
Well, it's not
the
one
extent
case.
that you,
These legal precedents go back to 1914.
I understand that, but, having spent 20 years working in the healthcare industry, which is one of the most highly regulated industries in our country, what I've come to know about laws is, we have a lot of them. So, I'm sure that there's a lot of cases out there, and a lot of laws that can be looked at. So I guess from, and listening to what Mike is saying, I don't understand how what you've presented here and what we've received is so definitively binding to such a quick and immediate action, and doesn't afford the town the ability to take care of its residents' interests and, more comfortably transition what we need to transition to make sure that the court can continue to operate functionally.
Well, I would suggest it's not so simple. The determination of the Commission on Judicial Conduct, that's dated August 20th, and the Attorney General's letter to Peter was dated August 24th. So they've been out there. They both come to the same conclusion. It's, conclusion that there isn't anything on the other side. When people talk about the advisory opinion, it's this other entity on judicial ethics that has the least amount of weight. The municipalities are directed to the Attorney General's office for a statement on the law. That's their obligation. Catherine Scheingold, who is the Assistant Solicitor General, the Solicitor General is the person at the AG's office, sort of number 2 in the office, who issues these opinions, and since I've been involved in municipal law for 20-something years, Catherine Scheingold, I think, has been there for all of those years. She knows what she's talking about.
I'm not saying she doesn't. I guess what I'm saying is, what I don't understand is how we don't have the ability to put the town's and the residents' interest in the forefront and handle this in a way that doesn't provide for a great amount of disruption
Well,
for them and for their operation.
I think that we don't know what the disruption would be, because we do still have a town judge, and I believe we still have a court clerk. So, and if the attorney for Judge Van Wert wants to challenge his opinion, then he probably wants a determination that he could then challenge in court. Because if there's no finality, then he has nothing to challenge. You can't just go to court when there's no case or controversy.
I understand. I'm not debating the opinions or what we should do. I'm debating with you how we do it.
Right, and what I'm suggesting is that maybe the easiest way to get a resolution is for the judge's attorney to either bring this proceeding by way of an order show cause, which is the quickest way to get into court, and that would be the fastest way to get a direct resolution of this question.
I guess I don't have a question. I'm not questioning whether or not, I read what was provided, okay? Assume that I agree with that, okay? What I guess I'm questioning is the process or the time frame and how we go about handling it. If the judge's attorney wants to challenge, by all means, I think that whatever rights and opportunities that she should have new applicants. So, and if there's a different opinion or ruling that comes out, then we need to take that into consideration. I do agree with Mike. I just think we need, that if we're going to buy into what you've discussed, it needs to be done in a more thoughtful way than, just today. I think that would provide a disruption for the operation of our court, personally.
I just have to give you the legal ones, and that's just that we're not going to get anything more from the Attorney General. They'll say, as they have, basically, we have spoken, and the rest is up to you. I mean, the risk, if you were to, to basically ignore the Attorney General's opinion for now, is you open yourself up to a taxpayer action to say that you misuse town funds by continuing to pay after you were told that you can come back.
I mean, you just said the case law goes back to, prehistoric times. So this has been in existence here since 1997. So I think as long as we figure out what we're going to do and we make some decisions and publicly put a plan in place on what we're doing that meets the advice that has been provided to us, I think, personally, I think we can be fine. If we did nothing, then I think we're exposing ourselves. But if we do what Mike is suggesting, put a plan in place that can accommodate for the ongoing functional operation of the court, I don't think we're exposed. That's my opinion. So is there any other public comment?
I just want to make a comment that, I still stand where I stand, but I certainly don't want to be getting called to Albany to chat in front of the Attorney General. Ask the rest of the board to weigh in.
I don't think we've got a choice.
We're in public comment.
Oh, I'm sorry. Sorry. Oh, okay.
And what were you just doing, talking? You were just discussing it. I got my comments,
Please, I apologize.
I just don't think we've got a choice.
Well, we are in public comment, so thank you, Michelle. Let's finish going here, and we'll close it up and go to councilman concern. So the floor is open to everybody.
Probably a bad time, but
We want to
change the subject. Thank you. But I just wanted to bring up the solar panel discussion. I wanted to update you guys, let you know that I have spoken to New York Light and Energy, and we're in the process of getting Doug Cole, New York Light and Energy, and myself together. I was under the impression that they were going to talk to each other, but they didn't. Doug Cole's been on vacation for a little while, so I'm taking the initiative to actually meet with him and sit down with him and go over what the possibilities are in placing these solar panels on the different properties. I did come up with, I had Doug Cole come up with a quote of around $1,000 to do all three properties, and I wanted to let you guys know that ahead of time before we actually started doing anything. So are you guys comfortable with that price range? I mean, that's a fairly good, in comparison to other agencies, you're probably paying a lot more than that. So $1,000 is pretty reasonable, but I just wanted to let you guys know that ahead of time. Is that okay? Do you want me to go forward? Do you want to hold off? I mean, you let me know.
Would you include me in on these meetings?
Sure.
Or-
Absolutely.
You know, I tried calling Doug this morning, and you know, he's on vacation,
Right.
so, yeah, anything we can do to keep the ball rolling.
Exactly. Like we have a planning board meeting coming up this month. I wanted to have at least a preliminary plan ahead, basically completed for us to basically review. But my goal right now is to meet with Doug, have a preliminary plan drawn up, and actually send it back to New York Light Energy, see what they have, any comments back, or having any issues with it, and then maybe massaging it, making sure that it fits everyone's needs, and then actually go in front of the Princetown Planning Board. So before I did that, I wanted to let you guys know the cost that you guys are going to be eating in this case. It's going to be right around $1,000. I know that was an issue.
Do we know who the surveyor of the property was?
I believe it was CT Mail. I'm not
Here?
sure. CT Mail.
Was because Pete Rumpich from New York Light Energy suggested that if we approach CT Mail, they may be able to provide us.
We have those. We have the actual plans, the actual plot plans for the parcels. They don't have the actual buildings on them, but they give us the dimensions of the properties. So we can actually locate where our property lines are and kind of figure out exactly where everything is on that property. And that's where Doug Hole's going to come in and place those structures and any type of infrastructure that we do have on the properties on these maps. And we're going to try to place these solar panels somewhere on these maps where it makes sense, makes the most sense.
Right. Okay. So just to bring you a little more up to speed, and just for consideration at this point, right? And this goes, I guess, for everybody. So Mike has identified 12 or 14 areas on the power purchase agreement where there's probably room for negotiation.